The Fifth Amendment, Takings Clause. Common interpretation by Richard A. Epstein and Eduardo M. Penareth. The Takings Clause of the Fifth Amendment to the United States Constitution reads as follows: None shall private property be taken for public use without just compensation. You understand the provision, we both agree that it's helpful to keep in mind the reasons behind it. We agree that the clause intended to uphold the principle that the government should not single out isolated individuals to bear excessive burdens, even in support of important public good. When this happens, the payment of just compensation provides a means of removing any special burden. The most influential statement of this principle is found in Armstrong v. United States, 1960, where the Supreme Court wrote, "The Fifth Amendment's takings clause were designed to bar government from forcing some people alone to bear public burdens which, in all fairness and justice, should be borne by the public as a whole." For the takings clause to serve this principle effectively, we both agree that the guarantee of just compensation must apply, at the very least, to cases in which the government engages in the outright confiscation of property. This means more than merely the government taking a private-owned third asset for itself. It also includes situations in which the government permanently deprives a private owner of possession of the asset or gives the asset or the right to permanently physically occupy the asset to someone else. We agree that the compensation requirement must apply not only to land but to all forms of private property. At the minimum, this means that the clause applies to government confiscation of personal property, including interests as diverse as animals and corporate stock. The clause also applies not only to the confiscation of all existing interests in any individual piece of property, but to the confiscation of certain lesser interests in property. Under Anglo-American law, it would include recognized interests like easements, such as rights of way, leases, mortgages, life estates, and remainders. The clause also applies to the confiscation of intangible property, including intellectual property such as patents, copyrights, trademarks, and trade secrets. Although the clause has not been read to apply to taxes, it does apply when the government seizes a specific pool of money, such as a bank account or a bag full of cash, or when it orders an individual to pay a specific amount of money. We also agree that the clause prohibits the government from confiscating property, even with just compensation, if it is not doing so for a public use. Although the boundaries of this prohibition are controversial, we agree that it encompasses the minimal situations in which the government takes property from A for the purpose of giving it to B solely for B's private benefit. We agree that the phrase compensation means that the owner of the property shall receive at a minimum the fair market value of the property in its best alternative use, independent of the government's taking. In most instances, compensation requires is paid in cash. In some situations, government compensation may come in the form of some reciprocal or return benefits given to a party, such as increasing the value of retained land when the government builds a road over that property. Finally, we agree that under the takings clause, the government need not compensate private property owners when it requires them to take reasonable steps to avoid pollution or other releases that harm either public or private property in land, air, and water. Anytime some private party could seek court order stopping another private party from engaging in harmful activities, the government can impose the same limitations through fines and court orders without duty to compensate. With the advent of the modern welfare state, the complex regulations that come with it, more challenges than ever before, are raised under the banner of the takings clause. The breadth of state action, the diversity of its interactions with the private owners, have multiplied the gray areas in which the government burdens some owners more than others. The key area of dispute about the meaning of the taking clause relate to how much the government may burden an individual property owner before triggering its obligation to pay just compensation. These are the areas on which we shall offer our separate and different views. Matter debate. The first perspective, taking the clause toward a unified approach for the occupation and regulation of private property. By Richard A. Epstein. The central challenge of the takings law is how best respond to two issues. The first involves so-called regulatory taking, where the government leaves the owner in possession of his property but restricts either its use or disposition, that is, by limiting it to residential use or prohibiting sale. The second deals with exactions. The government announces that it will only issue a permit or license to a property owner if the owner, in exchange, either turns over part of that property to the government, pays cash to the public treasury, or pays for off-site repairs or improvements to benefit the public as a whole. In both settings, the modern view favors a low level of judicial scrutiny, commonly called the rational basis test. Unfortunately, that test is unsupported by anything in the text of the takings clause. Unfortunately, it opens all government decisions to unacceptable risks of faction and political intrigue. The mischief starts with the three-part test announced in Supreme Court 1978 decision in Penn Central Transportation Corporation versus the City of New York. New York City Landmarks Preservation Commission prohibited the owner of the Grand Central Terminal from constructing a multi-story office tower above the terminal. Under New York law, the owners of the terminal own the air rights above the terminal that they could either use or sell. The landmark restrictions wipe out the value of those air rights, but the city offers them no compensation to offset the loss. In upholding the city's actions, Penn Central did not treat the government action as a taking of the air rights, but as a restriction on land use governed by the three-part test, which look at 1. The economic impact on owners. 2. A set of investment-backed expectations, how investors expect to use the property. And 3. The character of government regulation, under which land use regulations were subject to far less scrutiny than government occupation of property. Unfortunately, Penn Central never asked the right social question, which is whether the net cost of the regulation will exceed its social benefits. That test would be met if the city were forced to buy the air rights above the landmark terminal, which the city would not do if the public gains were smaller than the private losses. But it gobbled up those rights because it did not have to pay 1 cent to acquire them. Penn Central's three factors are all sideshow to the main event. The economic impact on owners is a measure of harm for the loss imposed. But just as which physical taking the size of the loss is irrelevant to the question of whether compensation is owned, the reference to the investment-backed expectations is needless obscurantism that is just is a brain invoke in an ad hoc way by announcing without proof that Penn Central's chief interest in the success is the current terminal, which hardly shows that the company placed no value in its air rights. Finally, The character of the invasion, physical or regulatory, offers no explanation as to why the two forms taken should receive different levels of scrutiny. The crack follows a disproportionate impact test for Armstrong versus United States, 1960. If landmark designation wants city beautification, the public and not the single owner should bear its entire cost. This outcome makes sense whether or not we see that the government of Penn Central now occupies a now unusable airspace. The problem of exactions raises similar issues. The government, of course, has the right to issue permits and licenses for potentially dangerous activities, but it cannot withhold them on a whim. It would be wholly improper for any government agent to tell a landowner that she may only build if she pays $1 million into the public treasury to fund general improvements, which should be paid for by general taxes under the Armstrong formula. The result does not change if, as in Nolan versus California Coastal Commission, 1987, the government tells the private owners that she can build an ordinary house on her own property only if the public receives a full free land through public easement across the front of his land. The same logic applies if the government insists that it will issue a building permit on one half of a plot of land, and if the landowner transfers the other half if it is free of charge or dredges a public river. Now, how then to distinguish proper conditions from improper exactions? The best test asks whether the government condition is intended to block action which, if allowed to take place, would create the kind of nuance that the government would probably stop by legal action. Some conditions, such as making sure that the dirty water from your plant does not enter the river, meet that test, but the others, repairing public facility along the river, does not. To meet the Armstrong test, those last improvements should be funded by the public at large and not foisted off on the last to build. Increasing the level of judicial scrutiny of both regulatory takings and exactions will not block much needed government regulations, but it will help control the non-stop political intrigue so common today in land use regulation and elsewhere. Next perspective, regulatory takings and equitable judgment. By Eduardo M. Penalver. The most controversial questions in takings law involve determining when the government must compensate a property owner whose property has been burdened by regulation. The same principles justify requiring compensation when the state confiscates property for public use, preventing government from forcing some people alone to bear public burdens, which, in all fairness, justice should be borne by the public as a whole. Armstrong vs. United States, 1960. Also seem to justify occasionally requiring compensation when an owner bears exceptionally heavy regulatory burden. But try to generalize about when the state should compensate regulated property owners has proven exceptionally difficult for both courts and legal scholars. In one 2005 case, Lingo versus Chevron, USA, the Supreme Court helpfully clarified that in considering whether to compensate property owners, decision makers should not focus on the rationality or wisdom for the regulation in question, but rather on the fairness of the burden imposed on owners. An exercise the state's police power must be minimally rational, but the best constitutional framework for invalidating rationality is not the degree to which the restriction advances the legitimate state purpose. The standard for review that the court applied to certain suspect state actions under the Due Process Clause. In the regulatory context, the question to which the Takings Clause directs itself is whether a valid exercise of police power nevertheless impose such a heavy burden on the property owner that the state must pay compensation. The principal legal rubric, sorry, difficult word. Let me check it out the meaning, okay? Rubric means a heading on a document. I'm so sorry. Rubric, okay? The principal legal rubric through which the course evaluates and burden was set forth in the Supreme Court 1978 decision in Penn Central Transportation Corporation was New York City. In that case, New York City designated Grand Central Terminal a historical landmark. It prohibited the owner of the terminal from building a multi-story office tower on top of it, in considering whether to require New York City to compensate the owner's Grand Central Terminal for the burden of designating the terminal as a historical landmark. The court discussed three factors. One, the economic impact of the regulation on the owner. Two, the degree to which the regulation interferes with district investment-backed exploitation. Three, the character of the government action. All three factors focus on different ways in which a regulation might burden owner. The first factor looks to the economic loss the regulation causes. The second focuses on the degree to which the regulation unsettles expectation about how the property will be used under an earlier, more permissible regulatory regime, expectation of which the owner has relied in some way. The third turns to other considerations that might color our interpretation of the fairness of the regulatory burden, for example, by asking whether the state is intruding on the owner's privacy or singling out the owner for unfavorable treatment. In a few contexts, the Supreme Court has supplemented the flexible Penn Central factors with more rigid rules, such as when the state authorizes permanent physical occupation of property, or when it regulates the property to such extent that it leaves the owner with no economically viable use of the property. But those rules are both correctly exceptional and narrow. As frustrating as the Penn Central's indeterminate factors are to some commentators, they properly leave courts with broad discretion about when to require compensation to burden owners and do a good job of guiding this fairness-based inquiry. The question for when to require compensation for onerous regulations were rules, no substitute for sound judgment. Another taking contest in which the court had deviated from the Penn Central approach concerns so-called exactions, where a government conditions regulatory approval on the owner's handing over some property, either money or some in-kind property interest, to the government. The idea of property owners paying for regular permission strikes some as closely resembling corruption or extortion. In serious cases, the Supreme Court has held that when the government conditions regulatory approval and the owner's handing over of property interests, courts must scrutinize exactions to ensure one, that they share a logical connection, nexus, with the reasons why the state might legitimately deny regulatory permission in the first place, and two, that they are roughly proportional to the impacts of the action for which the owners are seeking regulatory permission. All of the exemptions do provide an opportunity for government abuse of property owners. They can also serve as a valuable tool for increasing flexibility in regulatory structures while ensuring that owners' use of their property does not impose costs on the community. In scrutinizing exactions, courts should focus on those situations in which the burdens of exactions have the greatest potential to fall unevenly on regulated owners. Consequently, courts should defer to the government where exactions operate in a transparent general way, akin to taxation. For example, exactions that call for the payment of money according to a formulaic schedule laid out in advance should receive differential review in court. And then conclude this clause.